Welcome to this episode of Law and Society in Taiwan. And today we will talk about laws and regulations in more detail. So let me ask you, what is law? Why do we care about laws? And we find a definition in the Constitution in Article 170, which says law is any legislative bill duly passed by the Legislative Yuan and promulgated by the President. So this is a rather formalistic definition, right? It looks at the procedure. Yeah, if we have been complying with the procedure in the Legislative Yuan, then this is a law, right? But from a substantive perspective, let's ask ourselves, what is so special about the content of a law? And in this regard, we will discover that a law is a binding norm. Binding means it has to be followed. Everyone has to follow the law, because otherwise what will happen? You will be punished. Yeah, so binding norms must be followed under the threat of punishment. But I think it's important not just to remain at this point and to say, okay, laws are here, we care about laws because otherwise you will be punished. Because actually, law has another very, very important function, maybe even more important than that of punishing. Yeah, so let's ask ourselves, why do you think that laws are important? Why do we need laws? And could you imagine what our world would be like without laws? Do you think it would be a good world to live in, or would it be very chaotic? Would it be very dangerous? And if you really think about this, yeah, what would happen in a world without law? Then anything could happen, right? Anyone could just come and could kill you or take away your things, and nothing would happen, right? So if we think about law from this perspective, actually there is a very positive perspective about law, namely the purpose of law is to maintain a peaceful society. So the purpose of law is to maintain a peaceful society. So if people don't comply with the law, when there is a conflict, then we try to resolve the conflict by applying the law, by going through a legal procedure. So I think this is very important to emphasize, that the primary purpose of law is not so much to punish, but much more to protect a peaceful society. So now that we know what laws are and why they are so important, it's important to realize that not all laws have the same character or the nature. So here we have a legal hierarchy, the ranks of laws. And the supreme law in all countries, including Taiwan, is the Constitution. So the Constitution ranks above all other laws, such as codes or statutes or ordinances. And according to Article 171 and 172 of the Constitution, laws and ordinances that are in conflict with the Constitution shall be null and void. So the Constitution here uses the term null and void, which means absolutely invalid. Apart from the Constitution, we have codes and statutes, also often called acts, that are passed by the legislative yuan. And then below the codes and statutes, we have the so-called regulations and legal orders or ordinances. So in Chinese, the term here is 法规, which we translate with regulations, and 命令. 命令 in English is sometimes translated as legal order or ordinance. And these regulations and legal orders or ordinances are issued by the administrative or executive authorities according to Article 150 of the Administrative Procedure Act. But they still have external legal effects, and in this, as a result, are similar to law. So seen from this perspective, they also have legal effects. They are binding, meaning that the people have to follow these regulations and ordinances. And because of this legal effect, it is important that the administrative authorities who pass these kind of regulations or ordinances, they need a law to authorize them. So there must be a legal authorization, and when the administrative authority then makes this kind of regulation or ordinance, they have to specify the law that gives them this kind of authorization. And the scope of the legal authorization must not be exceeded. So why is this so important? Well, we know that laws, as a general principle, have to be passed by the legislative, and the legislators, they are directly elected by the people. So this is democracy. This is how democracy works. On the other hand, the administrative authorities, they are not directly elected by the people. So if they want to make a binding regulation or legal ordinance, it is important that they receive the authorization from the law. And in this way, then they have the authority also to make the administrative regulations and ordinances that have the similar effects just like the laws. And according to Article 158 of the Administrative Procedure Law, these kinds of administrative regulations and ordinances must not contravene the Constitution, the laws, or the regulations from superior agencies. and they must not restrict the people's freedoms or rights without legal authorization. If they do, so if they do contravene the Constitution, or if they restrict the people's rights without legal authorization, what is the effect of these administrative regulations and ordinances? The effect is that they will have no force and effect, meaning that again they will be void because they contravene the Constitution. Yeah, so it's important to understand here the legal hierarchy, that the laws have different ranks. Okay, so here now comes the test question. What is the supreme law in Taiwan? What is the difference between statute and ordinance? The next question, what is the effect of laws that contravene the Constitution? And then finally, give 2 reasons why an ordinance can be void. Okay, so now you know what is a law, why we care about the laws, and the ranks of laws, yeah, so that there is a legal hierarchy. Now we want to talk about these laws in more detail, and of course we have to start with the supreme law, which is the Constitution. The Constitution of the Republic of China was adopted in Nanjing, in China, by the National Assembly, 国民大会, on 25 December 1946, and was promulgated on January 1st, 1947, and became effective later that year on 25th December of 1947. So this is important to note, right, that the Constitution of the Republic of China was originally adopted in mainland China. But we also know that the government then moved to Taiwan. And during this first period, when the government came to Taiwan, the Constitution did not apply because it was a special time of martial law, and this period of martial law only ended in 1987. So since 1987, we start to have democratic governance and the rule of law in Taiwan, and since this time then we really effectively start to apply the Constitution in Taiwan. But this history, looking at this history of the Constitution already tells us it's necessary to adapt the Constitution to the new circumstances in Taiwan. And that is why the Constitution has been amended in the course of 7 rounds or 7 revisions, namely in 1991, in 1992, 1994, 1997, 1999, in the year 2000, and in the year 2005. So in total, the Constitution has been amended 7 times, and as a result of these 7 rounds of amendments, we now also have the 12 additional articles. So here you see the original Constitution, we have the preamble, we have 175 original articles, and we have the 12 additional articles which have been added to the Constitution as a result of the 7 rounds of amendments or revisions. So we now first take a look at the preamble. The preamble says the National Assembly of the Republic of China, by virtue of the mandate received from the whole body of citizens, in accordance with Dr. Sun Yat-sen in founding the Republic of China, and in order to consolidate the authority of the state, safeguard the rights of the people, ensure social tranquility, and promote the welfare of the people, does hereby establish this Constitution to be promulgated throughout the country for faithful and perpetual observance by all. So what do we learn from this preamble? First of all, it mentions the National Assembly, and the National Assembly, according to Article 25 of the Constitution, shall exercise the political powers on behalf of the whole body of citizens. So according to the original Constitution, the power comes from the people, but the people do not directly exercise the power. Rather, it is the National Assembly who shall exercise the political powers on behalf of all the citizens. And the preamble here also mentions the state. So the purpose of the Constitution is to consolidate the state, and on the other hand also to safeguard the rights of the people. Yeah, and this is very important, yeah, to have this kind of relationship, yeah, a balanced relationship. On the one hand, to maintain a strong state, but on the other hand also to protect the people so that the government will not abuse its power. And finally, tranquility. So the preamble here mentions the word tranquility, which means peace. No violence and worry. And this again highlights what I just said in the beginning, right? That the purpose of law is peace, to maintain peace. And this is also highlighted here in the preamble. Yeah? So the Constitution here shall ensure social tranquility or peace and the welfare of the people. And now, if we take a look at the 175 original articles, they are divided into 14 chapters. And you can see the titles. Yeah, we have the general provisions, the rights and duties of the people, the National Assembly, the President, the administration, the legislation, the judiciary, the examination and control, the powers of the central and local governments, the system of local government, election, recall, initiative, and referendum, and the fundamental national policies, and then finally the enforcement and amendment of the Constitution. So to make it clear, the structure of the original Constitution, it talks about the individual rights and freedoms. And this is very important, yeah, to emphasize that these fundamental rights and freedoms of the people are guaranteed by the Constitution itself, which is the supreme law of the nation. And then the Constitution also talks about the government structure. And I already explained to you in a previous session, in a previous episode, that the government structure here is divided into 5 branches. And the power of the government also is divided between the central and local government. And then finally, the Constitution talks about fundamental national policies. So this brings us to the test question. What is the main content of the Constitution of the Republic of China? The next question is, how does the Constitution divide governmental powers? Okay, now that we know the main content of the Constitution, we now want to take a more detailed look at the content. So we start with the rights and the freedoms, but also the duties of the people that are enshrined in the Constitution. If we look at the rights, the Constitution mentions the right to equality in Article 7, the right to existence, work and property in Article 15, the right to petition, to file complaints in legal proceedings in Article 16, the right to election, recall, initiative and referendum in Article 17. So these are the elements of direct democracy. And then in Article 18, the right to take public examinations and to hold public offices. And in Article 21, the right to receive education. Freedoms are guaranteed by Article 8, personal freedom. Article 10 mentions the freedom to choose your own residence. Article 11 mentions the freedom of speech, freedom of teaching, writing, and publication. And Article 12 ensures the privacy of correspondence. Article 13 ensures the freedom of religious belief. And Article 14, the freedom of assembly and association. But of course, we know people do not only have rights and freedoms, but also some duties. And the Constitution here mentions the duties to pay taxes in Article 19, the duty to perform military service in Article 20, and the duty to receive education in Article 21. So the receiving education is both a right but also a duty according to the Constitution. Now the interesting question is, what do we do if we don't find a special right listed? Is it still protected by the Constitution? And the answer is in Article 22, which says all other freedoms and rights of the people that are not detrimental to social order or public welfare shall be guaranteed under the Constitution. So thanks to Article 22 of the Constitution, we know that even if a right or a freedom is not expressly mentioned, but it can still be protected by the Constitution, and one example is, for example, the right, the freedom to marry, which is not expressly mentioned, but is included under Article 22. And the other question that we have to ask here is, are these rights and freedoms guaranteed or protected 100%? And we know here that we also still, even though we enjoy these rights and freedoms, but we still have to respect other people's rights and freedoms. And therefore, that's why sometimes it may be necessary to restrict the freedoms. So these rights and freedoms are normally not protected 100%, but according to Article 23 of the Constitution, the freedoms and rights can be restricted, but only they can only be restricted by law. So first of all, we need a law, and these exceptions have to be necessary. So if we want to restrict these rights and freedoms, it has to be necessary to prevent the infringement upon the freedoms of other persons, or to avert an imminent crisis, to maintain social order, or to advance public welfare. So if we want to restrict a right or a freedom, first of all, we have to ask, it has to be in the public interest, yeah? So we need a law that must be in the public interest. And then on the other hand, it has to be really necessary in order to achieve the public interest. So Article 23 tells us that it's possible to restrict the rights and freedoms, but only if it is necessary and if it is in the public interest. The test question, which right and which freedom and which duty do you consider to be most important, and explain why. So take a look at the table, the overview that I provided for you with all the rights, freedoms, and duties, and choose one from each and tell us why you think that is so important for you. And the next question, can the rights and freedoms mentioned in the Constitution be restricted, and if so, under what circumstances? Now that we have talked about the fundamental rights and freedoms that are protected by the Constitution, now let's take a look at the additional articles. As I already explained, the additional articles are the results of the 7 rounds of amendments that revised the Constitution. We know that the Constitution was originally adopted in mainland China, but effectively it does not apply in China, on mainland China, but only to Taiwan now. And that is also why, according to Article 11 of the additional articles, it now provides, it says, rights and obligations between the people of the Chinese mainland area and those of the free area in Taiwan, namely, the disposition of other related affairs may be specified by law. So effectively, this means in practice, the Constitution now applies in Taiwan, and with regard to the mainland, we have special laws. So I'm not going to explain again the additional articles in more detail. But let me just ask you now the exam questions. Why does the Constitution have 12 additional articles? And the next question, how can the Constitution be amended, and how often has the Constitution been amended? Okay, so we have now discussed the Constitution. It's now clear that the Constitution is the highest law, and it has been amended several times. Under the Constitution now we have the codes and also the statutes that are passed by the legislative. But to clarify the difference between statute and codes, so of course both are considered laws, both are black letter laws, and the statutes are defined as law passed by the legislative body, namely the Legislative Yuan in Taiwan. But a code now, what makes a code so special is that it is a systematic collection of the laws or statutes. And in Taiwan, we have distinguish different major codes, and we can divide them into three big areas, namely public law and private law and criminal law. So let's first talk about public law. Public law governs the relations between a person and the public government authority. So it's a kind of vertical relationship. The private law, on the other hand, governs the relations between private persons. Yeah? So if we have a private person with another private person, this is a kind of horizontal relationship. And then we have the criminal law, which protects certain values that are important for the entire society, for society as a whole. So now you understand the distinction, yeah, between public law, private law, and criminal law. These are the three main areas of law. And in each area of law, we have the codes. So in public law, we have the Constitution, as we already mentioned, and in addition to the Constitution, we also have the administrative law, in particular, the Administrative Procedure Act of 1999, in Chinese called 行政程序法, which regulates the procedure that has to be applied by the administrative authorities. In the area of private law, we have the Civil Code. In Chinese, it's called the 民法典, which was first promulgated in 1929, and also the Code of Civil Procedure, 民事诉讼法, which regulates the civil procedure. And in the area of criminal law, we have the Criminal Code dating from the year 1928, and also here we have the Code of Criminal Procedure to regulate the procedural questions. So now here comes the test question. What is the difference between public and private law? And what is the difference between civil and criminal law? And what are the most important codes in Taiwan? Give at least 3 examples. So now let's take a closer look at these codes. And we start with the Civil Code. The Civil Code is divided into 5 parts. The first part talks about general principles. And here it, for example, defines what is a person. A person can be a natural person or a juridical or a legal person. A natural person, according to Article 6, is a person because of birth. Yeah? So once you are born, then you are a person and you have legal capacity, which means you have certain legal rights. You are able to have certain legal rights. On the other hand, juridical persons are defined in Article 25 of the Civil Code. They are established not by natural birth, but by law. So it's the law that confers the legal capacity on these legal persons. And according to Article 30, a juridical person cannot be established unless it has been registered. Yeah, so the typical example for this would be companies. Yeah, companies are legal persons, and they have to be registered. So as soon as they are registered, they become effective. Talking about natural persons, the Civil Code here also uses the term capacity to make the juridical acts. So we have to distinguish between the legal capacity on the one hand, which means more generally to have the rights and the legal rights, but on the other hand, we also need the legal capacity to act. And the legal capacity to act, in order to have this kind of legal capacity to act, Article 13 says the minor who has not reached the 7th year of age has no capacity to make juridical acts. The minor who is over 7 years of age has a limited capacity to make juridical acts. And then Article 12 says majority is attained upon reaching the 18th year of age. So here we see the different ages that are important according to the Civil Code. So first of all, as soon as you are born, you have a legal capacity. But before you reach the age of 7, you are a minor and you don't even have the capacity to act. So here you need your guardians, your parents, yeah, who will act on behalf of the minor or the child. Once you reach the age of 7, you have limited capacity to act. So for example, then you would be able to buy small things that you need for daily life, daily necessities. And then once you reach the age of 18, then you are no longer a minor, but you have reached the age of a majority, and then you have the full capacity to act. The first part of the Civil Code not only talks about the persons, but it also talks about the things. So this is the big distinction between persons who can have legal rights, but also legal obligations. And on the other hand, we have the things or the objects. And here we distinguish between real property and personal property. According to Article 66, real property is, for example, land and things which are constantly affixed thereto. Whereas according to Article 67, personal property is anything except real property. Yeah, so this is the big distinction here. When we talk about property, we distinguish between the real property, such as the real estate, the land, and other personal property. Part 2 of the obligations. Part 2 of the Civil Code talks about the obligations. And the sources of obligations can, for example, be contracts or torts. So what is the difference now between contract and tort? A contract is an agreement, and according to Article 153, it is concluded when parties have reciprocally declared their concordant intent, a contract shall be constituted. Yeah? So as soon as we reach a mutual assent between the two parties, they have an agreement, then this is a contract. On the other hand, a tort, this is, according to Article 184, defined as a person who intentionally or negligently has wrongfully damaged the rights of another, is bound to compensate him for any injury arising therefrom. So a tort is something wrong. Yeah? When you do something wrong, you damage somebody else or injure somebody else outside a contractual relationship, then you have to compensate that person, and so you do something wrong, this is a tort, and then you have to compensate that person. So we see that contracts and torts are examples for obligations. Part 3 of the Civil Code talks about rights in rem, and rem means things. So the rights, to have the right over a thing, this can be called ownership. And ownership means to have all the rights. Yeah, you have all the rights, and you can exclude other people from exercising any rights over the things. Yeah, so Article 765 defines the owner. Yeah, it says the owner of a thing has the right to use it, to profit from it, to dispose of it freely, and to exclude the interference from others. And the owner of a thing also has the right to demand its return from anyone who possesses it without authority. So here we see the distinction between ownership and possession. So what does possession mean? Possession is defined in Article 940, and it says a possessor is a person who has controlling power de facto over a thing. So possession means to effectively have control over a thing, whereas ownership means to have all the rights with regard to this thing, right? So you might be the owner of, let's say, a dog, for example, but if I take away your dog, then I'm possessing it, I have it in my control, yeah, then I'm possessing the object, that dog, yeah, even though you are the owner, yeah, of the dog. The next part, part 4 of the Civil Code, talks about family, and in particular, it talks about marriage, yeah, and then once you marriage, it talks about the relationships between parents and children. So you see there is a logical system, right? Yeah, so first you have to marry, and then you have children, yeah, and when you have children, then we have to regulate the relationship between the parents and the children. And then finally, part 5 of the Civil Code talks about succession. So this is when a person dies, who are the heirs who will inherit all the property. Yeah, and Article 1138 says heirs to property other than the spouse come in the following order, and then they name the lineal descendants by blood. So these are the children. Then we have the parents. Then we have the brothers and sisters, and then we have the grandparents, yeah, who might inherit. And then the Civil Code also talks about the will. So the last will of a person means a person can dispose, right? What shall happen with all my property? And Article 1187 here says a testator, yeah, may freely dispose of his property by a will, so far as it does not contravene the provisions in regard to compulsory portions. Yeah, so the testator is the person who wants to decide what to do with my property, and he can decide by making a will. So this gives you an overview of the Civil Code. Yeah, what is the main content of the Civil Code? Now comes the question, what is the difference between natural person and a legal or juridical person? The next question, which code is relevant for contracts and torts? So if you have a contractual or a question about torts, which code is applicable? And what is the difference between ownership and possession? Does an owner always have possession over a thing, or is it possible that ownership and possession are separate? Now that we have talked about the civil code, we now take a look at the criminal code. And the criminal code here again also is divided into a first part dealing with general provisions. And in Article 1, it defines when a conduct is punishable, namely only when expressly so provided by the law at the time of its commission. This is a very important principle, yeah, that a criminal law only applies when there is an express provision at the time of when we commit an offense. Yeah, so if today I do something, but there is no special criminal law to penalize, then I cannot be punished by the criminal law. Then under the general principles, it also talks about criminal responsibility. And Article 12 says a conduct is not punishable unless committed intentionally or negligently. A negligent conduct is punishable only if specifically so provided. Here we see the distinction between intentional crimes and negligent crimes. And why is this distinction important? It's important because a negligent conduct or negligent crime is can only be punished when the criminal code so provides. Yeah, so therefore it's important for us now to understand what does intentional mean. And a definition is we can find in Article 13. It says a conduct is committed intentionally if the actor knowingly or is aware that the act will accomplish the elements of the offense, and if such accomplishment is not against his will. So if I know, yeah, or if I know that I might be doing something, I might be injuring something, and I say, oh, I really don't care about it, even if that happens, I don't care. Yeah, it's not against my will. This qualifies as intentional. Whereas a negligence means, this is defined in Article 14, it says a conduct is committed negligently if the actor fails to exercise his duty of care or that he should and could have exercised in the circumstances. So negligence means you have a duty of care, there is a certain standard, and you don't comply with this duty of care, you don't comply with this standard, then you are acting negligently. Article 16 also provides a very important provision, because it says criminal responsibility shall not be excused simply because of ignorance of the law unless there are rightful reasons for being unable to avoid the offense, but the punishment may be reduced according to circumstances. So this answers the question, right? If I say, oh, sorry, I didn't know the law, is this a good excuse? Well, here Article 16 says ignorance of the law shall not be excused, right, unless. Yeah, so this is important that in principle, once the laws are published, it's not a good excuse to say, oh, sorry, I did not know the law. Article 18 also is important because it says an offense committed by a person who is under 14 years of age is not punishable. Punishment may be reduced for an offense committed by a person more than the age of 14, but under the age of 18. So this is now interesting if we compare it with the civil code. So according to the civil code, right, I mentioned there is a threshold of 7 years and then 18 years. And according to the criminal code, we also have the threshold of 18 years. So once you're 18 years, you are fully responsible for your behavior. But under the age of 18, here we have a threshold year of 14 years. Yeah? So if you have not reached the age of 14, then you are still a minor and you can not be punished. But if you are in between 14 and 18, then you can be punished, but you will be tried in a special court, in a so-called juvenile court, and where you enjoy certain privileges, and the punishment can be reduced. The criminal code then talks about attempt. So what is an attempt? According to Article 25, an attempt is a conduct performed in the commission of an offense that is not accomplished. An attempt is punishable only if specifically so provided, and the punishment may be reduced from that for an accomplished offense. So today, if I try to shoot you, but I'm missing you, I don't really manage to shoot you, then this is only an attempt. Yeah, maybe I wanted to kill you, but I did not accomplish my intent. Yeah, and therefore this is only an attempt. And then the question is, can I still be punished? And the answer here, only if so provided by the criminal code. So now let's continue to talk about the punishments. Punishments are divided into principal and accessory punishments. And Article 33 lists the principal punishment. So what is the first, the most serious punishment? The most serious punishment in Taiwan is the death penalty. And there is the discussion right now whether or not to abolish the death penalty. We know, for example, in the European Union, no member state is allowed to have the death penalty. In the United States, some states still practice the death penalty, and in Taiwan, we also still have the death penalty. Then comes life imprisonment and other imprisonments, other forms of imprisonment, short-term imprisonment, and then there can also be a fine. So fine means you are not imprisoned, you don't have to go to jail, you just have to pay money. Sentencing. Let's talk about sentencing. Article 57 says sentencing shall take into account all circumstances such as the motive and the purpose of an offense, the stimulation at the moment of committing an offense, the means that are used for commission of an offense, the living conditions of the offender, the disposition of the offender, the education and intelligence of the offender, the relationship between the offender and the victim, the seriousness of the offender's obligation violation, the danger or damage caused by an offense, and the offender's attitude after committing an offense. So when it comes to sentencing, so really how much do you have to pay, or for how long do you have to go to prison? We have these circumstances that have to be taken into account, yeah, such as really why did you want to commit this crime, and very important here also is the attitude, yeah. So if a criminal then expresses regret, for example, and is really sorry for having committed the crime, then his sentence might be alleviated. And then we have the statute of limitations. So what does this mean? Statute of limitations we find in Article 80, where it says prosecution is barred by limitation if not exercised within the following periods. So statute of limitations. Limitation means to restrict the time when you can file the lawsuit, when you can prosecute somebody. And if you wait too long, then after the time has passed, then it's not allowed anymore to prosecute this kind of person. So this is the meaning of statute of limitations. Yeah, it means the time when you want to initiate lawsuit is limited. This is the general part of the criminal code, and then part 2 of the criminal code talks about specific offenses. And we don't have the time to talk about all these offenses in detail, but I only want to list the values that are protected here, such as public safety. Just to give you an example, drunk driving, yeah, is punished here according to Article 185/3. Yeah, if you drink too much alcohol and you drive the car, this is a big danger for public safety, and then this is you can be punished by the criminal code. Or marriage and family is also a value that is protected by the criminal code. But what is important to note here is Article 239, which says a married person who commits adultery with another shall be sentenced to imprisonment for not more than 1 year. The other party to the adultery shall be subject to the same punishment. But this Article 239 of the Criminal Code has been deleted. Why? Because it has been declared unconstitutional by the Judicial Yuan, the Constitutional Court, in May 2020, when it was found that it is not necessary to have a criminal punishment for adultery because it violates the privacy of a person, and this is unconstitutional. So this is a very a landmark judgment also, and Taiwan here in this regard is one of the last countries in Asia to delete this kind of provision from the criminal code. So to decriminalize adultery, so if you commit adultery, it can still be, you might still have to compensate according to the civil law, but it is not punishable by the criminal law anymore. Other values that are protected by the criminal code are life, of course. Yeah, if you commit homicide, such as Article 271 says a person who takes the life of another, yeah, commits homicide, and an attempt to commit an offense is also punishable. So this is to protect the value of life, and also bodily integrity is protected by the criminal code. So if you injure somebody, then this can be punished. Freedom is another important value protected by the criminal code. Article 305 says a person who threatens to cause injury to the life, body, freedom, reputation, or property of another and thereby endanger his safety can be punished. It's interesting also that reputation, right, is a very important value that is protected by the criminal code, according to Article 309. For example, yeah, a person who publicly insults another can be punished, but there are certain exceptions, of course. Privacy is protected, for example, by Article 315. When you use instruments or equipment without reason to peep or eavesdrop on another's non-public activities, speeches, talks, or private parts of the body, you must not interfere. You have to respect the privacy of other persons. Property, for example, is a value that is also protected by the criminal code by Article 328. It says a person who uses violence, threats, or other means to render resistance impossible and to take away property of another or cause him to deliver it over for purpose to exercise unlawful control over the other person's other's property commits robbery. Yeah, so robbery here is an example where the criminal law protects property. And then last but not least, also computer security in our modern times is protected by the criminal code. Article 358, for instance, says access to another person's computer or related equipment by cracking protective measures or exploiting loophole of the computer system without any reason is punishable by the criminal code. So now you have an idea of the specific offenses, and even though we don't talk about the offenses in detail, you know what are some of the major values that are protected by the criminal code. So we can now ask, under what circumstances is a conduct punishable? And is ignorance of law a good excuse? And what is the difference between intention and negligence? And is a negligent act always punishable? And can children be punished according to the criminal code? Is the attempt to commit an offense always punishable? So we have now talked about the criminal code, but we also have a code of criminal procedure. So the Code of Criminal Procedure in the part 1 talks about general provisions, and in Article 3 it defines the term party. It says refers to a public prosecutor or an accused. So this is now important to know that in a criminal proceeding, in a criminal trial, the parties are, on the one hand, is the accused, but the person who initiates is called the public prosecutor. So this is different from the civil procedure. In a civil procedure, we have the plaintiff and the defendant. The plaintiff is the person who initiates the lawsuit against the defendant. In a criminal lawsuit, the plaintiff is called the prosecutor, and the prosecutor is part of the government. Yeah, so they initiate, prosecute the accused on behalf of the government. Article 5 talks about the jurisdiction of the courts and says a court of the place where the offense has been committed, yeah, or where the accused is domiciled or resides or is located shall have jurisdiction over the case. Yeah, so the question in the beginning, if you want to prosecute somebody, yeah, you have to find the specific court, and normally we can go to the court where the offense was committed or where the accused is living or is located now. Next is the summons and the arrest of the accused. So if we want to summon the accused, we have a summons shall be issued. A summons shall be signed by a public prosecutor during the investigation stage or by a presiding judge during the trial stage. This is according to Article 71, and Article 75 provides an accused who without good reason fails to appear after he has been legally summoned may be arrested with a warrant. And Article 93 says an accused or suspect arrested with or without a warrant shall be interrogated immediately during the investigation. If the prosecutor deems it necessary to detain the accused or suspect after interrogation, a petition shall be submitted to the court for a detention order within 24 hours of making the arrest. So this is the primary stage of investigation, when the prosecutor maybe already has a suspect or really thinks that somebody might be the accused person, then we want that person to come. So we can interrogate or ask or question that person. We can do this by summoning this accused or suspect. And if this accused or suspect does not come, then he can be arrested. But normally, in order to arrest a person, we would need a warrant, which is a court order, a special permission. Then, if the accused now comes, then we will start the examination. So we start to investigate, to question. Article 95 says the accused shall be informed before an interrogation of the alleged crimes committed and the criminal charges, the right to remain silent, and the right to retain an attorney. So this is very important to emphasize. Before the interrogation starts, before we start questioning the accused, yeah, he has the right to be informed. What are the crimes? What are the charges? What do we believe that he committed? And very important also, he has the right to remain silent. Yeah, so we cannot force the accused to speak or to acknowledge that he committed a crime. Yeah, so he has the right to remain silent, and he has the right to retain an attorney. And if he cannot afford to pay for his lawyer, then it's the government who will pay for an attorney. After the examination, the judge may order that the accused may be released on bail, or if necessary, he can be detained. Yeah, so this now depends on how serious, what is the risk. Yeah, can we release the accused on bail? Bail means he has to pay a certain amount of money, yeah, to guarantee that he will not escape. Yeah, he will continue to come when we call him, or is it really necessary to detain him? And detention of the accused may not exceed 2 months during the stage of the investigation and not exceed 3 months during the stage of trial. However, if necessary, the court may extend such a period by a ruling. So according to Article 108, the detention must not exceed 2 months in principle, but the 2 months detention can be prolonged if necessary. Then we have a chapter about search and seizure. Article 122 says, if necessary, the person, property, electronic record, dwelling, or other premises of an accused or a suspect may be searched. So the search and seizure, of course, is important to find the evidence. We know if we want to prosecute somebody successfully, then we need the evidence. And in order to find the evidence, it might be necessary to go to the house of the accused and conduct a search and seizure. But in principle, also for this, generally, we would need a warrant or a court order. And this brings us to evidence. So evidence is to prove that the accused has really committed the crime. But according to Article 154, prior to conviction through trial, an accused is presumed to be innocent. So this is a very, very important principle that in the first place we have to assume that the person is innocent. And then it's up to the public prosecutor to prove that really this person has committed the crime. So Article 161 says the public prosecutor shall bear the burden of proof as to the facts of the crime charged against an accused. This is important to emphasize, right, that the accused is assumed to be innocent, and it's up to the prosecutor to bear the burden of proof. It's the prosecutor who has to prove and come up with the evidence that the person really committed the crime. Yeah, unfortunately, often it's in practice. Yeah, as soon as we hear somebody has been accused, there is already a kind of feeling, right, or prejudice, yeah, that this person has committed a crime. But it's all the more it's important to emphasize, right, that according to the criminal code, we should assume the opposite, yeah, namely that this person is still innocent. And according to Article 175, a witness shall be called to testify by subpoena, and the witness can be fined or arrested if he fails to appear without a good reason. So the witness is a person who has observed with his own senses, maybe saw or listened or heard how the crime was committed, and this kind of witness then can be called to the court using a subpoena. So subpoena means under the threat of punishment. Yeah, so the witness will receive a court order, and the court order will specify if you, the witness, don't appear in the court, then you can be punished. Yeah, so your testimony at the court is very important for us to use as the evidence to prove whether or not the person has really committed the crime. And then finally, a decision will be made. Yeah, so after collecting all the evidence, a decision shall be in the form of a ruling, unless the code provides that it shall be in the form of a judgment, according to Article 220. So the outcome can be a judgment on the substantive matters. If the judge rules on the motion of a party, for example, with regard to procedural questions, then this would be made in form of a ruling. Part 2 of the Code of Criminal Procedure now next talks about the trial of the first instance. So we know that in the first instance, it's the public prosecutor who will start the investigation. Article 228 says if a public prosecutor, because of complaint or other reason, knows there is suspicion of an offense having been committed, he shall begin an investigation. Article 264 says a public prosecution shall be initiated by a public prosecutor by filing an indictment with a competent court. And he shall include the name of the accused, the facts, the evidence, and the law that was violated. So the indictment is the formal accusation, yeah, when the prosecutor formally accuses a person of having committed a crime. Article 271 says the court shall summon the accused and notify the public prosecutor, the defense attorney, and also notify the date of the trial. So then the judge will set the date for a trial. Now, if during the trial the accused admits that he's guilty, it is possible to go through a summary trial. So summary trial is a form of simplified trial. And this kind of summary trial is only possible under certain circumstances and is excluded in serious cases. Yeah, for example, when there is the possibility of death penalty or life imprisonment. Yeah, but otherwise, if this is an easier case, not so serious, and the accused admits that he is guilty, it is possible then to have a summary or simplified trial. According to Article 299, if an offense committed by an accused is proved, so the prosecutor has enough sufficient evidence, then a judgment imposing a sentence shall be pronounced. On the other hand, according to Article 301, if it cannot be proved that an accused has committed an offense, or if his act is not punishable, a judgment of not guilty shall be pronounced. So the outcome is either guilty or not guilty. Now, if he is found guilty, what can the accused do? And this is regulated in Part 3, dealing with appeals. There can be an appeal to the second instance. So Article 361 says a person who disagrees with a judgment of the first instance made by a district court shall file an appeal to the Court of an Appeal with jurisdiction of the second instance. A written petition of appeal shall set forth specific grounds of reason. Yeah? So if we have a criminal trial in a district court, and we don't agree with the judgment, then we appeal to the court of second instance, but we need the specific grounds of reasons. Article 375 says a person who disagrees with a judgment of the first or second instance made by a court of appeal shall file an appeal to the Supreme Court. So we have the district court, and then we have the second instance, the Court of Appeals, and then finally we have the third instance, the Court of Appeals. The Supreme Court. And, the Supreme Court is the court of third instance, and they will have a trial without an oral argument, so they only decide questions of law, but they can order an argument, an oral argument, a hearing if necessary, according to Article 389. Part 7 of the Code of Criminal Procedure gives the details for the summary procedure. So I already mentioned the summary procedure is a kind of simplified proceeding, and Article 449 now says the first instance court may decide on a sentence using summary procedures upon the prosecutor's request without going through the regular proceedings. If the court finds that the defendant's confession as provided during the investigation or other existing evidence is sufficient to determine the defendant's guilt. If the prosecutor has begun prosecution following regular proceedings, but the court then decides that summary procedures are appropriate for the sentencing phase of the trial after the defendant confesses the crime, summary procedures may then be adopted. The pronounced criminal sanction is limited to probation, fixed term imprisonment that is convertible to a fine or community service detention or a fine. So we see summary procedure allows a simplified procedure under certain circumstances, in particular when the accused has confessed that he really committed the crime. And then finally, and this is interesting also to note, that Part 7/1 allows a bargaining process also in Taiwan. And according to Article 455/2, this is possible except for cases that involve crimes punishable by death or life imprisonment. Then the prosecutor may, with the court's consent, negotiate on following items outside of trial proceedings before the end of closing argument in first instance court or issuance of a summary judgment. Once all parties agree on the details and the defendant pleads guilty, the prosecutor may petition the court to make a judgment in accordance with the bargaining procedure. And so now these are the requirements. Yeah, that first, the defendant agrees to the criminal sanction. Second, the defendant shall apologize to the victim. And third, defendant shall pay a commensurate amount of compensation. In Article 455/3 says, where a defendant violates the agreement with the prosecutor, the prosecutor may revoke the request for plea bargain. So this is the key word here. Plea bargain means that it's possible for the prosecutor and the accused to bargain, yeah, to find a common consent about how to resolve the conflict. Yeah, maybe the defendant agrees, he admits his guilt and he's willing to pay a certain amount of money, and in return then the prosecutor might offer a slighter sentence, and then in this way reach a conclusion of this trial. So now that we have talked about the criminal law and also the criminal procedure, we finally want to take a short look at the Administrative Procedure Act. The Administrative Procedure Act applies, has the purpose to ensure that all administrative acts are carried out in pursuance of a fair, open, and democratic process based on principles of administration by law. So this is the principle that all administration has to abide by the law. In Chinese, 依法行政的原则,依法行政的原则. So it's very important here that the administrative procedure follow the law. And administrative procedure, this term is defined in Article 2. It says it's a procedure that must be followed by administrative authorities in performing certain acts, such as rendering administrative dispositions, entering into administrative contracts, establishing legal orders and administrative rules, deciding on administrative plans, employing administrative guidance, and dealing with petitions. And in Article 2, we also find a definition of the term administrative authority. It means an organization representing the state, any local self-governing body, or any other subject of administration with an independent legal status in declaration of its intention and carrying on public affairs. An individual or entity commissioned to exercise public authority shall be deemed to be an administrative authority within the scope of the commission. And perhaps the most important provision of the Administrative Procedure Act, we find in Article 150, 158, and 159. Here it defines what is a legal order. In Chinese, they use the term 法规命令. 法规命令, and the Administrative Procedure Act defines this with a legal order, but maybe a better translation would be a regulation or ordinance. And this means it's an abstract prescription with external legal effects. So this is important, that the legal regulations and ordinances that are made by the administrative have external legal effects, and in this way are comparable to the laws. They're established by an administrative authority as enabled by law in respect of general matters and applicable to a multiple number of non-specified persons. And because of these external legal effects, a legal order, regulation, or ordinance shall specify the authority conferred by law based on which it is established and shall not transgress the scope of such authority or divert from the legislative purpose of the enabling law. So this is what I mentioned also today at the beginning of this course, that the administrative authorities, they are not directly elected by the people. Nevertheless, they have the power to make the regulations and ordinances that have the similar effects just like laws. And therefore, in order to make this kind of administrative regulation or ordinance, we need a law that authorizes the administrative authority to make this kind of regulation or ordinance. Yeah, and this kind of authorization, yeah, the law has to be specified by the administrative authority. Article 158 says a legal order, or we can also say, translate it with regulation or ordinance, shall be of no force and effect if it conflicts with the Constitution or is inconsistent with laws or orders of a superior authority, or if it deprives people of their freedoms and rights without authorization by law. So this is what I already explained in the context of the legal hierarchy. Yeah, so the the administrative regulations and ordinances are below the laws that are enacted by the legislative, and so these administrative regulations and ordinances must not violate the superior laws or even the Constitution, and if they do, then they are invalid. Article 59 defines the term administrative rules. So the rules are generalized and abstract provisions issued by superior authority to lower units, or by superior officer to a subordinate officer by virtue of his or her powers for the purpose of regulating internal orders and operations with no direct external effects as legal norms. So here you see the difference, that administrative rules only apply internally. They do not have external effects, and the rules are issued by a superior authority to be applied by a lower officer. And this is also a characteristic of the administration. Here, the officers, the public officers, they are not independent, yeah? But there is a hierarchy meaning that the officers have to obey their superiors. So this is very different from the judiciary, where we emphasize that each judge is independent. Yeah, they must not obey the superior. They make the judgments only according to the law and according to their conscience. Here in the administration also has to follow laws, but there is a hierarchy within the administration. Conclusion: the primary purpose of law is not to punish, but to protect a just and peaceful society. The supreme law in Taiwan is the Constitution of the Republic of China. It was drafted under circumstances very different from today, and therefore has been subject to substantial amendments. Even today, calls for constitutional reforms continue to be in the spotlight. Apart from the Constitution, there are currently 5 major codes governing administrative procedure, civil law and civil procedure, as well as criminal law and criminal procedure. Statutes passed by the legislative are often complemented and specified by administrative regulations or ordinances that have a subordinate rank, but nevertheless can have great relevance in practice. So this concludes our session for today, and I hope you now have a clearer understanding what are laws and regulations.